Both the defense and the prosecution head to court this morning. It does look like that court hearing is underway. Let's listen in.
So help you God. Thank you. You can have a seat. May I call the case, Your Honor?
Please.
Your Honor, this is 2282 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of the Chief.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of the
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of the
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yanetti for Karen Reed.
Good morning, Ms. Yanetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. Good morning, ladies and gentlemen. My name is Beverly Cannoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on how your day is going to shape up. As you know, jury duty is one of the most important civic duties we have as citizens of this country. Our system of justice simply would not work without you, so we appreciate that you're here today, ready, willing, and able to serve if you're called upon to do so. Now, as you've heard, this is a criminal case. It's the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence of alcohol and leaving the scene after causing personal injury or death. I will describe those crimes in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that Ms. Reed is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices. But this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for jury service on this case, please do not think it's a reflection upon you and don't take it personally. We don't think that somehow you're not a fair person. You will be directed back to the jury room and perhaps picked on a different case. In a little while, I'll pose a number of questions to you as a group. You have taken a note that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask at the time that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read them. You don't have to take your cards out now. I'll tell you when you need to take your cards out. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that the lawyers and I need to discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer that question at sidebar. I may have additional questions for you which relate to issues in this case that may be raised during the trial and are designed to give us more information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask the questions for the same reason. This is not a test. There is no right or wrong answer. We simply want your best, most honest answer to our questions. At this point, I'm going to ask the lawyers to introduce themselves, and counsel for the defendant, introduce your client, please.
Yeah.
Please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. I'd like to also meet my colleagues.
Good morning, my name is Laura McLaughlin. I'm an assistant district attorney representing the communities of Norfolk County. Thank you for being here this morning.
Morning, my name is Adam Lally, Assistant District Attorney with the Norfolk County Attorney's Office. I just want to thank you all for your time and attention and for being here.
Okay, thank you.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the honor and privilege of representing Karen Reed, who is standing to my right.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the honor of representing the jury.
Good morning. My name is Robert Alessi. I have the pleasure of representing Ms. Reed, and I thank you all for being here and for your time today.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have offices in Boston and right here in Dedham. My privilege to represent Karen Reed.
Good morning, everyone. My name is Victoria George, and I also have the privilege of representing Ms. Reed.
Good morning, I'm Karen Reed, and thank you for being here.
All right, thank you all. Folks, I'm about to read you a rather lengthy witness list. I'd ask that you pay close attention to the names on this list. It doesn't mean that every single name you hear, that person will be called. There'll be names that will be called now that might be mentioned during the course of the trial. So it's really important that we understand whether or not you know these folks. So that will be a question I'll ask you. The names are alphabetical, but they're alphabetical by first name. Aidan Kearney from Jefferson, Massachusetts. Dr. Isaac Wolf from South Miami, Florida. Alfred Lopalato from Canton, Allison McCabe, Canton, Andre Porto, who is with the Massachusetts State Police Crime Lab, Andrew Klain from Bridgewater, Andrew Rentschler, who is a PhD from Pittsburgh, Pennsylvania, Angela Malvone from Canton, Annie Chung from Canton, Anthony Flamati from the Canton Fire Department, Ashley Bell from Canton, Ashley Valaire from the Mass State Police Crime Lab, Brian Albert, Norwood, Brian Albert Jr., Boston, Brian Higgins from Sandwich, Brian Loughran, Canton, Brian Wanless, who is a retired officer of the Canton Police Department, Bridget Meehan, who is a keeper of the records from Canton, Caitlin Albert, Easton, Lieutenant Charles Ray from the Canton Police Department, Canton Police Chief Helena Rafferty, Chris Van E., who is a PhD from Novi, Michigan, Christina Hanley, Mass State Police, Christopher Albert, Canton, Christopher Curran, Canton, Colleen Crawford from the Norfolk DA's office, Colin Albert, Canton, Courtney Proctor, Canton, Kurt Roberts, also Canton, Daniel Whitley from the Canton Fire Department, Daniel Wolf, who is a PhD from Penns Park, Pennsylvania, Derek Ellington from Wake Forest, North Carolina, Dr. Marie Russell, who's from Los Angeles, Dr. Elizabeth Loposada, who is from Providence, Rhode Island, Elizabeth Proctor, Canton, Eric Hanlon, Canton, Erin Beatty, Canton, Erin O'Keefe, West Bridgewater, Francis Walsh from the Canton Fire Department, Garrett Wing, Green Cove Springs, Florida, Gary Fowler from Brockton, Gregory Woodbury from Canton, Gretchen Voss, Boston, Hannah Knowles from the Mass State Police Crime Lab, Heather Maxon, Walpole, Erabito Hernandez from the Boston Police Department, Holly Price from Mountain View, California, Ian Whiffen from Vienna, Virginia, Dr. Irene Scorti-Bello, who is with the Office of the Chief Medical Examiner here in Massachusetts, James Crosby, who's a PhD from Jacksonville, Florida, Janet Reed from Dighton, Jason Becker from the Canton Fire Department, Jean DeMoulis from Canton, Jennifer McCabe, Canton, Jessica Hyde, Bridgeport, New York, John O'Keefe Sr., who lives in Braintree, Judson Welcher, PhD from a company called Aperture LLC, Julie Albert, Canton, Julie Nagel, Canton, Dr. Justin Rice from South Weymouth. There are 2 juveniles from Canton, one of whom has the initials KF and the other PF. Caitlin Boudreau, Raynham. Karina Kolakithas from Canton, Katie Camerano, Canton, Katie McLaughlin from the Canton Fire Department, Keeper of the Records for Ring from Hawthorne, California, Kerry Curran, Canton, Kerry Roberts, Canton, Kevin Albert, Canton, Kevin O'Hara with the Massachusetts State Police, Lance Mello from the State Police Crime Lab, Laura Sullivan, Pembroke, Laurie Cahill, Worcester, Leslie Pearlstein, Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jutras, Canton, Lieutenant Brian Tully, and Lieutenant John Fanning, both from the Massachusetts State Police, Lieutenant Paul Gallagher from the Canton Police Department, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato from Canton, Margaret O'Keefe, Canton, Marietta Sullivan, Pembroke, Mary Souza, Dighton, Matthew Amory from Canton, Matthew DeSogra, who is from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly, Canton Fire Department, Matthew Kelsch from the FBI, Matthew McCabe from Canton, Maureen Harnett, Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano, Canton, Michael Easter, Los Angeles, Michael Trotter from the Canton Public Works Department, Michael Wagner, Foxborough, Mike Maroli, Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Wyweek Berschneider from San Marino, California, Nathan Reed, Raynham, Nicholas Bradford, Lorton, Virginia, Nicholas Curran, West Roxbury, Nicholas Kolakathis from Canton, Nicole Albert from Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barros from the Dighton Police Department, Patrick Haggerty from Somerset, Mass., Paul Wachowski from Melrose, Paul O'Keefe, Canton, Rebecca Bison, Canton, Rebecca Trayers, Norfolk, Mass., Dr. Renee Stonebridge, who is also from the Office of the Chief Medical Examiner in Boston, Richard Green, St. Pete Beach, Florida, Richard Donato from Canton, Robert Gilman from Hull, Ryan Nagel, Canton, Sarah Levinson, Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good, Canton Police Department, Sergeant Paul DiGiampetito from Canton Police Department, Sergeant Yuri Buchanan, Mass State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh, Canton, Sophie Herzan, who is from the Mass State Police Crime Lab, Stephanie Devlin, also the Crime Lab, Stephen Mullaney, Canton Police Department, Steve Nelson, Norfolk County DA's Office, Stephen Bernstein, who is a keeper of the records from Stoughton, Stephen Ridge, Boston Police, Stephen Seraph, Canton Police, Stephen Scanlon, West Roxbury, Terry Kuhn, who is from Davis, California, Tess Chart, Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall, who is with the Canton Fire Department, Tristan Morris, Easton. The following people are from the Mass State Police: Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, and William Reed from North Dighton, Mass. Those are the potential witnesses that you'll hear. So as you can tell, it's a long list of witnesses. This is going to be a long trial. The lawyers tell me that their best estimate on how long the evidence will take after we select a jury will be 6 to 8 weeks. We're in the process of selecting a jury. There's no way of knowing how long this process will take. So the trial itself, the evidence will take 6 to 8 weeks, and then the jury deliberates for as ever long as the jury needs to deliberate. So that's our schedule. For a daily schedule, what we will do is we'll start at 9. We'll have a break mid-morning around 11 o'clock for 20 minutes or so. We'll break for lunch around 1. That will be about 45 minutes. We'll have lunch brought into you folks, so you don't have to walk downtown and get lunch. We'll have lunch here for you every day. And in the afternoon, we'll go until about 4 o'clock, maybe some days later, some days earlier. Every day before we recess, I tell the jury whether or not we are ahead of schedule, on schedule, or behind schedule. And I can tell you, I don't think I've ever told a jury that we were behind schedule. So we try and keep things moving for you folks. So that's the schedule that we'll take. There'll be a few days and a few half days sprinkled in there that when you're selected, you'll get a schedule. Now, it might help if I give you a preview about some basic law that applies to all criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal rules and principles that will govern the trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. An indictment is a formal manner of accusing a person of a crime in order to bring that person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make the determination after listening to and considering all of the evidence. So another similar important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word. If a defendant chooses not to testify, please know that it has nothing to do with the question of whether that defendant is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law, instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people in a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't get everything that I said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree to the law, but all jurors have to follow the law and apply it as I describe it. So for jury selection, it's important to know if any of you might have some doubts whether you can accept and follow these legal principles. So now you can take your test because I'm about to ask you those questions. But before we begin, I understand that sometimes jurors don't fill out the questionnaires completely. Sometimes we're in a rush to get those forms in, or we might think that our situation does not apply to the question that's being asked. So because of that, if you know now that you may have left something out on your form, like maybe you were a witness to a case or a party in a case in court or a criminal defendant, if you've left anything out, please let us know at sidebar. And also, we will ask you if there are things missing. Like some people I've seen haven't put their age on the form. So if it's not there, I'll ask you your age and other things like that. So, all right, first question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses? If your answer is yes, hold the card up until the court officer reads off your number.
703 705
687
679.
678.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County DA's office? I see one.
726.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. If you have seen, heard, or talked about this case, would you please raise your hand now?
Juror 721 680 703 710 705 716 715 707 698 701 727. Need the space to get this with. 713 708 706 692 699 723 724 725 671 696
700 718 670 681 687 704 712 682 717 672 726 685 678 and 702.
673, 674, 675, 688, 711, 719, 722, 709, 690, and 679.
All right, thank you very much. Please raise your hand if you've expressed or formed any opinion with respect to this case.
Juror 721, 680, 703, 705, 716, 715, 698, 701, 713, 708, 706, 723, 671, 696,
687, 704, 712, 702, 685, and 672.
711, 688, 673, 674, 719, 722, 679.
All right, thank you very much. Are any of you aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If you do, please raise your hand.
Juror 721, 703, 705, 715, 698, 701, 671, 696.
687, 704, 712, 672.
711, 688, 673.
All right, thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
Juror number 702,
699,
719.
Okay.
709.
All right, thank you. Would any of you folks have any difficulty applying the very important constitutional principles that I outlined for you this morning? First, that the burden of proof rests entirely with the Commonwealth. Second, that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden to do anything. Is there anyone who has any difficulty with those concepts? I see no affirmative responses. I can tell you folks that after every jury trial I talk to the jurors, and they tell me that they have found their service to be an interesting one, and many times they tell me it was a rewarding one. But I understand that for some jurors, sitting on this case may be a substantial hardship. We have causes us some inconvenience. This is more than just mere inconvenience. It's something that means you are excused for personal reasons to you, but the person sitting next to you has to then step into your spot. I generally think of it in terms of you have airline tickets or surgery scheduled for the period of time that this trial will go. But I will hear from anyone who thinks they have a substantial hardship. If that's you, please raise your card.
Juror 691, 680, 710, 705, 716, 698, 701, 713, 708, 706, 692, 723, 725, 671, 696.
670, 681, 672, 702.
711, 674, 675, 688, 719, and 722.
All right. Thank you. So in a minute, I'm going to leave the bench to give you a chance to fill out those questionnaires. I ask that you not talk to anyone or share with any other prospective juror any questions, comments, or concerns that you may have about jury duty, either generally or specifically about this case. If you have any questions or concerns, please feel free to bring them up to me at sidebar when we meet. So we'll leave now.
All rise for the court, please.